Oh, you want to go to your
That's me.
Okay.
You want to kick it off or?
Yep, I'm going to kick it off. I think we are live. So everyone, thank you for being patient and for the delay. We were having some technical difficulties, but we're excited you're here. We're excited to welcome back the Ask Me Anything with Joe Daniels, who is with Nelson Mullins and he's a partner and co-chair with the emerging markets, and emerging companies, excuse me. And today he's going to talk all about fundable legal startup structures to make sure startups have the information they need as they get ready to raise capital and what all they need to know. So I'm Devika Rao. I'm sorry, just to introduce myself. We do the marketing for Thai New York, and excited to be here. And Joe, kick it off whenever you're ready.
You got it. So this is a presentation which is maybe like a piece of a larger presentation I give before I explain how people can raise money. It's basically how do you set the startup up, but it applies at every stage of a startup's growth. In other words, before the first equity round, before the A round, before the B round, you basically have to tie up all these things because people, get busy actually building a company and they have to catch up on the paperwork right before the financing. So just keep in mind, it's not just for somebody that's just incorporated. So I am Joe Daniels. I'm a partner and the co-chair of the emerging companies practice at Nelson Mullins. This is a 125-year-old full service law firm. We have startup to Fortune 50 clients, and we have a department basically for everything a business needs: corporate IP, real estate tax, etc. 1,000 lawyers all over 43 states, with license to practice in 43 states, with 30 offices in the U.S. But we have a global practice because we've been around for so long. We have relationships everywhere. I'm personally working on French and Canadian and Asian deals right now. I'm the practice area that I'm a co-chair of is a 75 lawyer group, and we basically focus on helping companies form, set themselves up correctly for venture capital financing, raising those financings. I think I'm working on 5 or 6 financings right now. And then, of course, helping the companies expand through acquisitions and partnerships and commercial agreements, and then exiting through M&A or IPO. We're consistently, for many years, actually ranked in the pitch book and Chambers and Partners for this practice area. We represent thousands of startups and venture funds. For example, in 21, we did about 200 deals for more than $8 billion. And we have over 150 M&A lawyers and 40 capital markets lawyers. Those are the people that take companies public. And we also have a 60 lawyer IP group with specialists in most technical areas, especially technology and life sciences, who handle patent, trademark, and copyright, prosecution, litigation, and licensing. A bunch of litigators ready to sue and defend all over the U.S. I've been doing this for 26 years, including 8 in California during the .com days. I joined the group that took Netscape public and sold it to AOL in Palo Alto. Here are some of the big companies and funds and investment banks I've represented. I've done 25 IPOs and follow-ons, scores of M&A deals, and thousands of financings, usually focus on tech and life sciences. So gives you my background. We're going to talk about how to form up the right company. If we have time, what is IP? So this is a little diagram I show to basically explain the basics of what a startup is. That little blue box is the startup company. That's a separate legal person. We'll get into the type of legal person it is next. And you're probably, as the founder, the idea or the business development person who contributes the intangible assets of the business plan, perhaps some IP. On the right-hand side box, other people join as co-founders or as consultants or as employees. People who, like the CTO, developers, marketing, sales, all the personnel within a company. They provide services, usually often in exchange for some component of equity at a discounted salary, and then the investors are investing cash. And what this is showing you is that that's all getting incorporated all at the same time into a separate legal person other than you, for the reasons to be discussed, namely limitation of liability and other factors. When do you form the startup? Basically, when you have one co-founder or one other person involved is the best time to do this. Or even if you're by yourself, if you have a material contract or an obligation, because you don't want to be personally liable for that obligation. And if you are forming a classic startup that's trying to get venture capital or any kind of financing from other people in technology, life sciences, and consumer, the answer as to what type of entity to form is a C corporation, principally for this QSBS, qualified small business stock exemption. The company's got less than 50 million in assets, and you either get stock for free or in exchange for services or in exchange for an investment, and you hold it for 5 years. So this is a C corporation stock. Then the greater of 10 million or 10 times the amount that you invest in the company is exempt from capital gains taxes, which is a 2.5 million benefit if you get the stock in exchange for services, and if you invest like 10 million bucks, it could be $100 million exemption, which is huge for VCs. That's why it's preferred by VCs and angels. And they also don't want pass-through gain and loss because they themselves are pass-through entities, and many of their investors are not-for-profit institutions that cannot receive pass-through gain and loss, or there'd be a penalty. And then the corporate tax rate is low, as for right now. It's been proposed to be changed, but Congress is not acting on that yet. And then if you want, the question comes up, what state do you incorporate it? Arizona, California, Texas, New York. And the answer is I always provide is Delaware. And the reason why are the statistics that you see there. Basically, most companies are in Delaware that operate in the US, especially the 90% of new IPO companies percentage. It shows that some people, basically lawyers in other states other than Delaware, who are operating not at the highest levels, I would say, no offense, because they are uniquely familiar with Oklahoma law or Missouri law or Michigan law or whatever, they like to form their companies under the laws of that state, because all the New York lawyers and the Palo Alto lawyers, they don't know Missouri and Michigan law, and they have an advantage over those people. But the thing is that investors, all the major investors and underwriters and other counsel don't know those other states' laws. They've memorized Delaware law, so they make you reincorporate in Delaware. So that just basically increases your costs down the line. And the other thing is that Delaware law is a lot more certain because there's been a lot of cases resolved there. Like every day, they're resolving major business-related cases. So everybody who practices Delaware corporate law knows exactly what's going to happen. And we have a lot of certainty about it. Not so much, not at all as much with the other states. So before we get into what you should paper up and how to do that, I just want to give you some basics on what is a Delaware C Corp, right? Because understanding this helps you understand why you should do this or that with the documents. So stockholders, what are they? What are they? They have the power to elect the board of directors by plurality. Of course, they have the economic rights on dividends or liquidation, proceeds from dissolution or sale of the company IPO. They have an economic and a voting or a control rights. Keep in mind, majority ownership is not essential for control. However, you don't have, a lot of founders think, oh, I want to maintain 50% ownership, 50.1% ownership, so that I can always control the board of directors and thereby control the company. But that is not essential, because whenever we do venture capital financings, private equity financings, we put in place these voting agreements and proxies that basically has a negotiated, cabal of people that are controlling the company. You often have a founder control company. You often have a founder / VC shared control company, and everybody else is cut out of that. It doesn't matter how they vote or how they want to vote, rather, because they've all signed a voting agreement that says they're going to vote exactly as the agreement provides, whether it's founder controlled or shared or whatever. Next, the board of directors. What are the powers of the board of directors? They basically all the major corporate actions, controlling the hiring and firing of C-level officers, sale of the company, declaring a dividend, issuing stock. It's all controlled by the board. That's why it's absolutely vital. If you want to be in control of your company, you should have to control the board. So just one director is okay until investors start asking for board seats. But you do want to avoid deadlocks. If you have two founders and you have each of them on the board, that can create a terrible situation where one founder just disappears and never votes on anything, and you can't take any action. And there's not much you can do about it except for going to Delaware Chancery Court, and going through a litigation proceeding. So, avoid even numbered boards unless there's some way to break the deadlock. And of course, you want to seek to outnumber investors if you want to maintain control. That means, you have to, if you're going to put an investor director on the board with you, then you have to have a friend, a friendly director who will vote in your direction. Otherwise, your stock that's still vesting, for example, after the financing may be at risk. And then officers, the CEO, CFO, CTO, these people are in control day to day, but at the board's discretion. The board, can decide and has power to appoint and remove officers, fire officers, basically. Keep that in mind. You might be CEO, but if you lose control of the board, they can fire you, and then again, your vesting can get cut off. Your stock repurchase. Oftentimes, people talk about adding people with strong operational or financial connections to the board early on in a startup's life. And because of the control issue, we generally will advise why not make them an advisor instead, give them a small equity grant. And this has been the case in the venture community for decades for the reason I'm mentioning, which is if you have like 2 advisors on your board who have like combined 1% or 1.5% of the company each, and they only work on the company 3 hours a month, why should, and they may provide great introductions to investors and connections and all that, but why should they be able to outvote you in terms of controlling your company? So make them an advisor instead of putting them on the board. Okay, what's the first major type of documentation? There's basically 2 types of major documentation you want to get in place before you try to go out there and raise money. Number 1, equity documentation. Number 2, service agreements. Okay, so equity documentation first. Why? It avoids disputes between those 2 co-founders. You might, agree in orally or in an email or something that, it's going to be 60-40, but then, people change their mind and they want it to be 70-30 or whatever. So that's why it's good to have it in writing and signed. Tax issue as well. This is something we often come up against. People will want to just defer signing the documents because they're not really sure if this person deserve that much or the other person deserves this much or whatever. And then all of a sudden, I got a term sheet for $5 million on $20 million pre-money round, and I haven't papered anything in my company. And I want to and they want to close in 3 weeks. So think about it. If you have a $20 million pre-money and then you issue all the stock to the founders 3 weeks before the round, can you take the position that stock is worth 0 or close to 0 anymore? It's probably a better idea to issue the stock a lot earlier than that and take the position that it's worth 0 so you don't have to pay for it, right? Otherwise, if you issue it to yourself for free, there's a risk that the IRS will claim that you just gave yourself $20 million of ordinary income among whoever's getting that stock. Also, investors require it. They're going to want all the equity to be correctly papered all the time. Founders have put off correctly papering the equity, and we have to recreate the entire thing at the same time as we're drafting the transaction documents for the financing. You don't want to do that because it's expensive and it's time consuming right at the time when you may be trying to negotiate the financing. Everybody just gets all jammed up. So spread it out over time. And the good news is that sort of venture capital emerging company law firms like ours will often defer a lot of the cost for constant maintenance of these documents until you actually raise the money. So you don't have to worry about the principal. The principal concern of founders is I don't want to spend the money. I don't want to spend the time on this bullshit paperwork. But that sort of mitigates the problem. It's the natural solution to the problem. So what do you really need to do this? You just need this thing called the board approval and a restricted stock purchase agreement for restricted stock or an option agreement for an option. Not a lot. It's just 10 pages of standard forms for all of this. You don't want to try and do it on your own because founders will usually screw it up, and then we have to clean it up, and it costs more. But it's not that much. Okay, so what are the different types of equity? Real quick, there is restricted stock before your first priced equity round, and then there's options. First, restricted stock. So what is a price equity round valuation event? This is when you sell your stock for cash, okay? And one more thing on the sort of venture model is that we usually sell preferred stock for cash and give common stock out for services. And the reason why is you can grant your preferred stock on one day for $1, and then you can go get a 409A and grant options at 20 cents or 30 cents at a big discount. And then you can show people that they're getting these really valuable options that are already in the money by a big amount of money, and then pay them a discounted salary. Of course, they have to earn it over 3 or 4 years, et cetera, et cetera. But it's a great inducement. And so that's why we don't sell common stock for cash, because when you sell it for cash at $1 a share, and when you grant the options, you have to grant the options at $1 a share, and they're not in the money by the 70, 80 cents. So what you do, a price equity round is when you sell preferred stock for cash. If you look at Apple, Zoom, SpaceX is on Series N preferred stock, right? They did the equity rounds A, B, C, D, E, F, G, all the way up to N, right? That's just the way it's done under the U.S. system, mostly because of tax reasons. So anyway, a price equity round is when you sell preferred stock for cash, valuing the stock, and before that price equity round, you can arguably take the position that the company is worth $0 or $10,000 or some really small amount, because it's a complete startup. If people walk away, there's nothing there. There may be some IP there, but is anybody going to commercialize it, et cetera? This does not include, price round does not include safes and notes. So if you go out and you raise a safe or a note financing, especially with notes, you just have a bunch of debt now. So that that just creates negative on the balance sheet. You can still take the position the company is worth close to $0. When in that situation where you can take that position, you have not done the price equity round, we always grant the restricted stock because it's much better from a tax perspective. What it is just common stock that's on a vesting schedule. We'll talk about that vesting next, but the bottom line is that if you're going to vest over time, which we recommend for all people, you have to file this 83B election within 30 days of when you issue that stock. This is, yeah. Sorry. Okay, next, options. After the first priced equity round, you grant options. Simple as that, because you price the stock. You have to get a 409A appraisal to determine the exercise price. An option is right to purchase the same thing I was talking about before, common stock, usually at a fixed price, which is the 409A fair market value, usually for the earlier of 10 years or 90 days after the person leaves. So this is the next best deal from a tax perspective. You don't get any, option E does not have any taxes on the receipt of grant. And you can still grant restricted stock, but the recipient has to either pay that 409A price, which can be a lot of money, or they accept ordinary income. So a rich person may just take coming on board as a professional CMO or CEO, may take restricted stock because it's much better from a tax perspective, and then just add that into their tax bill for the year based on the 409A. Okay, we recommend vesting for all service providers. Why? All other personnel in the company, other than one we're talking about, want that person to vest, because if they leave early, they shouldn't keep all their stock. For example, if you split the stock between 3 founders 3 ways, and then one of them leaves after 2 weeks, it's not fair that they have a third of the company, right? You want to be able to buy back that stock or cancel it, right? So you need special agreements to be able to make that happen. You can't just snap your fingers and say, the stock has disappeared. It doesn't, you have to have an agreement, right? Because you can't get it back otherwise. And investors want all the shares to vest as well, because they want the people to stick around and actually build the company. So what are the typical vesting schedules for historically, classically, although this is investors are trying to erase this, is 3-year, 1-year cliff from the time that you start as a founder. You started a year ago, you incorporate, you set the vesting schedule a year ago, starting a year ago, and that means you've already got past the 1-year cliff. What is a cliff? That means nothing vests until the cliff. So 3-year, 1-year cliff means 1/3 after 1 year, 1/36 of the total shares each month after that. Someone who joins later, a consultant or an employee, is usually on a 4-year, 1-year cliff. That's the known international standard of vesting. 25% after 1 year, 1/48 each month after that. The reason for the cliff is, if you get the request to have people vest monthly, it comes out of the valley, is that you can only pretend that you're somebody you're not for a year. After that point in time, people are going to figure it out, if not before. Directors and advisors, 2 years monthly is the standard vesting schedule. But consider milestone-based vesting, operational milestone-based vesting, like sales targets and that sort of thing, because that can really narrowly incentivize people, right? Okay, service agreements, the other major type of document, and then we're almost done, actually. We have Q&A. So what does this mean? All advisors, consultants, interns, employees, any kind of personnel usually fits into one of those 4 categories legally, right? Should sign a service agreement when joining. Like an employee is a W-2, a consultant and an advisor is a 1099 person, and an intern is working for free. They work under special labor laws in all the different states, which are different. Like, for example, in most states, they're supposed to be getting more out of it than you are. But everybody knows that a lot of startups have all these interns coding, and they pay them very little. So you have to have a special agreement for these situations. Anyway, all the forms cover 5 important things for investors, and they are just absolutely incessantly obsessive about it and make a big mountain out of molehill anytime any non-compliance occurs here. They want everybody to sign one of these because it requires the personnel to not disclose to third parties any confidential information and to not use it for any purpose other than working for that company. Why? Because that is fundamentally required in order to protect trade secrets. If you do not take reasonable steps to protect your trade secret and it leaks out, then it's no longer owned by you. It's not a trade secret. That's it. If you didn't get somebody to sign it and they just blab it online, if they post it on YouTube, too bad, it's gone, not yours. Second, it requires that all of the IP that they create, whether it's a jingle or a code or genomic sequence or whatever, is owned by the company and not them, because otherwise they can say, that belongs to me, you owe me a royalty, or you can't use it. Thirdly, it prohibits non-solicitation of customers, suppliers, distributors, partners, affiliates, friends, whatever. Because why? Because people will leave and then try to steal all your customers when they go to a venture-backed competitor startup. Or your suppliers, or your employees and consultants too. And finally, in most states, you can include a non-competition provision for like a year after they leave that protects you for the obvious reason, and of course non-disparagement. That's how we get to 5 items, right? You want to try to tie the equity vesting in the service agreement to the equity agreement if you're going to give them equity. Keep in mind, investors will want all current and former personnel to have signed one. I represent VCs as well as on the company side. It's just part of the process. Please give us a list of all your current and former personnel. And then next, in a separate section, there's a question, please provide a copy of the service agreement or confidentiality invention assignment agreement with each one of those people. If you don't have it, there people will put that on a list of issues and start asking you, how did that person contribute to the company historically? So just really quickly, other important pre-funding items. You want to use NDAs, and I already said service agreements where possible to protect trade secrets. That means NDAs with potential counterparties, customers or suppliers, whatever. And consider filing for patent, trademark, and copyright protection by getting a free consultation from, for example, one of my partners in my intellectual property group. They love to talk to people about their IP, and they can generally quickly recommend a reasonable strategy in a cost-effective manner. Also confirm that your IP chain of title for personnel coming in from universities and other companies is clear, that they're not, if you think they're going to be adding value that may be owned by the other company or university, get a copy of the agreements with those and have your lawyers look at that really quickly to figure out whether or not, what the level of risk there is. And you got to have lawyers draft a review, and remember that deferral arrangement that can help before you get funded. Forms of customer, supplier, distributor, and affiliate agreements, because that is going to involve your IP, especially if it's like an IP licensing kind of or SaaS kind of situation. You want to protect your intellectual property. And any other important deals like joint development or licenses in and out of IP, just to protect the IP. And then you try to resolve all the regulatory and litigation issues with your company, because investors don't like if you do not know how to explain exactly what pathway to take. If you're a medical device, then 510K. If you're biotech, phase 2 clinical trials. If you're fintech, we have to get a broker dealer license, or whatever regulated. If you're in a regulatory space, regulated space, healthcare. Have you done HIPAA compliant software and privacy policy, that kind of thing. So let's try to move to Q&A if we can. Devika, are you still on?
I'm still here. Great presentation, Joe. Thanks for walking us through that. And I hope our audience, they were definitely interested, as we have some questions. So on YouTube, we have a question that says, aren't other states like Wyoming trying very hard to compete with Delaware for incorporating, especially with crypto-related businesses? Yeah,
absolutely. They are trying different pieces of legislation, including one that basically sort of made crypto legal in Wyoming. But the problem is that federal law, when enacted, preempts state law, so that law has no effect when it comes to the SEC and the IRS, and basically, I mean, that's basically kind of a like a business development thing for the state. And the other thing that Wyoming claims is that basically it works because if it sort of fools people into thinking that this is going to work, but in the end, we end up generally, reincorporating companies in Delaware if they're going to get funded by a smart person or an institution. And the other thing Wyoming claims is anonymity, but Delaware has the same level of anonymity. So it's just sort of like false advertising. That's my position on that. Don't quote me on that in Wyoming, though.
Okay. We have a bunch of questions, so we'll go to what are some best practices for establishing your board before a Series A or during the Series A process?
Yeah, I mean, the key that I was pointing out before is that you have to start thinking ahead of who your friends are going to be. A lot of people I tell them, hey, you're the only person on the board now, and such and such fund wants one seat, so you don't want to be deadlocked, and you want to be able to outvote them. So we have to put somebody on the board. And they're like, oh no, I don't have any friends. I can't trust anyone. You have to develop relationships with people in the same sort of industry, operational areas, maybe someone on your team who you can trust. This is obviously a difficult thing to come by in life, but you have to find, think about it. You have to find somebody. The other way to do it, of course, is you set up a voting agreement in connection with the financing that says that you personally, as the one founder, can designate both seats. So you put someone on who you think is your friend, and if they cross you, then you just replace them with someone else.
I think that's really great feedback. Let's see. Then we also have a question, basically, would you, about founder vesting agreements, and does it make sense to have all these kind of documents that you walked us through in place, even if founders are not sure about raising venture capital yet?
If you're not sure whether or not you're ever going to use other people's money to scale the company, if you think you can organically grow the whole thing, it's more like I don't want to call it a lifestyle, but definitely a lifestyle business would fit in that category, which is usually, just upon the case studies that have come across my desk in 26 years, a misconception, and people eventually change their mind. Then yes, you don't need to put this paperwork together. Maybe better to be an LLC. But the minute you conclude that your business needs other people's money to scale, then just switch it to a Delaware C Corp.
Okay, that's good feedback. What are international companies like in India or the Middle East? What jurisdictions make sense for them when they're raising downstream capital?
Well, every country has different subsidies for their local companies, and like all the time, European companies are fairly well supported in the early stages. Same thing in Asia, Middle East, India, even Pakistan. So, but when it comes to later stage financing, whether it's like Series Seed, Series A, and Plus, most of the venture capital is in the United States. Bottom line. So I do a lot of redomestication of companies from all over the world, including all those regions I just mentioned, into Delaware. And it's relatively easy to do that, but there are certain countries where they have all kinds of legislation in place to basically prevent that because they want to keep it all at home, tax the hell out of it. For example, India is especially difficult. But we have figured it out. We know how to do it. It can be done. And people, usually because of tax reasons, the longer you defer it, the more expensive it will be.
Okay, great. And I know you touched upon this a little bit earlier in your presentation, towards the middle, but we were talking about IP assignments. And just to kind of reemphasize it, why are they important for startups to have in place before raising a round from VCs or angels? And how enforceable are things like NDAs?
Okay, so it's two separate things. An IP assignment for a contractor. If you contract with someone, hey, I'll pay you $50 an hour to code this, blockchain software, whatever it is. If without an agreement that says that you own the code in exchange for the $50 an hour, the contractor owns the code, and there's no agreement as to what happens to it. Okay, and a lot of people who are contractors, they're smart. They'll say, you're not going to own any of the code until you pay me everything I invoice. And the invoices just never stop coming, right? It's like an extortion thing. Mm-hmm. Or they put in there that you get a license. They own it, but you get a license to it, maybe royalty free, maybe not. Maybe it's to be negotiated. So you got to be very careful with the contractor agreements. With an employee in the 50 U.S. states, there's a work for hire doctrine that says if they're working on the clock with your equipment and things like that, then the company owns the IP. But every VC investor wants that backed up by an agreement that says, I don't care what you were doing. If it has anything to do with this company while you're working at the company and you invent it, it belongs to the company, period. It just makes it more clear than default law. So it's absolutely essential. And in fact, I would recommend almost more than anything else that I talked about, that people insist upon advisors, consultants, employees, and interns sign an invention assignment agreement when they start working. Can't be 3 days later, it can't be 3 weeks later, because then you don't have any leverage to get them to sign it. The NDA is not effective to assign inventions. It only requires them to keep it secret and to not use it for any other purpose. NDAs are, how enforceable are they? And against an individual, individuals do things with massive risk all the time. They just, talk like Stormy Daniels, just go around talking about, whatever they want, even though they signed a quote unquote gag order or NDA.
Okay, that's good. When we have one more question from Craig Abbott, who's also a tenure board member. So thanks, Craig. He's asking, if no certificates of ownership were issued by the startup or they were lost by the investor, what can be used to prove the original investment at the time of sale of the company? There's a second question, but I'm gonna let you have that one first.
Yep. So obviously the evidence of payment, the accounting ledger, or your bank statement showing it going in, like wire instructions, that kind of stuff. And what the investor wants to receive is something signed by the company that verifies what security and what amount that they purchase. That's usually like a stock purchase agreement or a safe or a convertible note. That instrument's signed by someone who is validly the CEO of the company. That's the best evidence. And supplementary or backup evidence would be like a board consent of that company authorizing the issuance and sale of that security in a specific amount to that investor. But the typical evidence is the stock purchase agreement, safe, or other instrument.
Okay. And I think you sort of did answer the second part of his question, but I'll ask it anyway, just for our audience. Does the company have an obligation to retain investment records?
Well, that's a complicated question. I mean, they want to retain investment records, right? They should want to, because then they know who owns their company, who has whatever rights in that company, economic or otherwise. Sometimes records get lost, and then they have to be recreated based on whatever available evidence there is. Does it have an obligation? It's a difficult question. I have to think about that.
Okay, then we'll have to put a pin on that and get back to you on that, Craig. Is there any one last thing you would advise startups as they're kind of getting started and getting off the ground, as you're talking about fundable structures? Is there any one piece of advice that you wish every startup would have as they start this journey for themselves?
Yeah, the biggest piece of advice I've already talked about, which is get the equity and service agreements in place, and don't screw around. I mean, I can only say it so many times.
Okay. Well, thank you for that. Well, thank you so much again for having our Ask Me Anything with Joe Daniels. We will be back definitely next month with a new topic for our entrepreneurs and investors in our audience. So, Joe, thank you again for being available today. And we look forward to seeing you soon again on this platform and, of course, in Thai, New York. So thanks again, everyone.
Yep. Thank you. Have a great day.
You too. Bye.
Bye.